Tēnā koutou katoa. My name is Joel Colón-Ríos. I am the director of the New Zealand Centre for Public Law and professor of law at Te Herenga Waka, Victoria University of Wellington. This is the episode 3 of the New Zealand Lives in Public Law series. Today I have the honor of talking to Dame Sian Elias. We will talk about her early life and education, about her experiences, some of her experiences as a barrister and as a judge, and also about some of her views about key contemporary public law issues. Tēnā koe, Dame Sian. It's great to have you here with us today.
Thank you.
So in these interviews, we usually like to start from the very beginning. So can you tell us something about your childhood, about where did you grow up, and about what were your main interests back then?
I grew up in Te Herenga, which is the Waitangi Ranges in Auckland. It was a fairly idyllic childhood. We had lots of bush, and we played a lot in the bush. And I went to Te Herenga Primary School, and then to the Diocesan High School in Auckland. And as for what I was interested in, playing and swimming and all of those sort of activities, because we were on the west coast of Auckland and the surf beaches and so on, and also reading. I was mad about reading.
And what kinds of books did you particularly enjoy?
Anything, but particularly Russian novels and boys' adventures, I suppose. I used to read a lot of old-fashioned books and a lot of poetry. I always enjoyed poetry.
Did you ever write?
Yes, I did. I even had some read out on the children's program on 1YA, but they weren't very good. I think I took law because I was very keen to leave university from the lower sixth, as it was then called, not to have the final year at school. And I probably should have carried on with subjects like Latin and Greek, which I'd done at school, at university. But because I hadn't had that final year at school, I was looking for subjects in which I wouldn't be behind. So law seemed quite a good one, and I did philosophy, and I carried on with English, but in the end I just dropped back to do the law degree.
And what subjects within the law school, what courses do you remember as the ones that you really sort of enjoyed?
I loved public law. I liked crime. I had terrible trouble with contract and with tort, actually tort most of all. I think maybe partly because they were taught then in the second year, and they probably still are they? Yes. Contract and tort. And I think I hadn't clicked with law at that stage, but by the third year when I did public law, it all fell into place a lot more. I liked company law too, which again was a third year subject. I think you learn the habits of law. It's a different way of thinking, really.
Yes.
Yeah. Well, I do remember my first day in court because we were working in the firm I was working for. We were working on a big public law case, and the Anna's Minute case had just been decided by the House of Lords, and I had been working on that and doing some devilling for the senior partner who was arguing the case. And as we walked up to court in Auckland, he said to me, "I think you better argue that." So we got up to the court, and we were in front of Mr. Justice Cook, Sir Robin Cook, who at that stage had only recently been appointed to the bench and of course knew all the public law. And my senior colleague got up and said, well, I thought we would start with the law and Miss Elias will argue the law and then I'll talk about the facts. And Sir Robin said, well, it's probably better to start with the facts. But my senior colleague wasn't having any part of that, so I had to stand up. And I do remember being terribly nervous. And of course, Sir Robin knew everything. And I started at the beginning and was working my way towards Anna's Minnick. And he said, but that proposition, the old precedent in New Zealand, well, that didn't cut much ice with the House of Lords, did it? And so then we got into the conversation, and then it was a lot of fun, but it was a very nervous beginning. I was junior counsel in that, and I came into it after the case had been struck out in the High Court, and I was part of the team that argued in the Court of Appeal. It was led by Ted Thomas and had been put together by a really good legal team, including Rod Hanson, who later became a High Court judge. They had a theory of the case that I didn't quite subscribe to, because their theory was that we were there to protect rugby against itself, because the rugby union was thought to be shooting itself in the foot by going ahead with something which would turn off so many people following the 1981 tour and what it had done to New Zealand society. You're absolutely right that I think the 81 tour and its aftermath was very important in the attitude that the judges brought to the case, and indeed it's quite unusual in that they made that quite explicit, not in the actual decision that we argued and won in the Court of Appeal, but on appeal, but when the rugby union applied for leave to appeal the decision to the Privy Council, the judges were quite frank about how it was not an appropriate case for the Privy Council to hear, because no one who hadn't lived through the upheavals that had been caused in New Zealand by the 81 tour could really bring sufficient context to the case, which is quite interesting, because judges, particularly I think Sir Frederick McCarthy, who was brought in as an additional judge in the Court of Appeal, an acting judge in the Court of Appeal. He was retired at that stage, and his judgment is absolutely fierce on the subject that their lordships in London, this was not an appropriate case for them. But it does illustrate how law changes to meet the changing experiences and requirements of any society. I think it was said about about Brown and the Board of Education that it wasn't pondering over the text of the 14th Amendment that caused the scales to suddenly fall from the eyes of the judges. It was the fact that they knew that the world had changed and the law had to change too. So I think law always has to keep in touch with the currents of the times, and maybe the Finnigan and Recording case was one of those. But it was also a case, I think, where public law was moving, although my senior colleague Ted Thomas, Sir Edmund Thomas, a former graduate of this law school, he always saw the case as a private law case, because the theory of the case was based on the membership of the two plaintiffs in a local rugby club, and through that back up to the New Zealand Rugby Union, whereas I always saw it as a public law case. And I think it was at a time when public law was starting to really move, and the judges recognised that this was something that touched New Zealand society more generally than a quasi-contractual case. The lands cases, it's generally known as, because there's so many New Zealand Maori Council cases, although it wasn't just about lands, it was also about waters, which sometimes people overlook. And indeed we did get, in the end, a settlement about how waters would be left to be dealt with by cutting down water rights to terms of 35 years. So there was, that was an important part of the case. But the lands case was based on a statutory provision, as you know, Section 9 of the State-Owned Enterprises Act, which refers to the principles of the treaty. And indeed, the Treaty of Waitangi Act refers to the principles of the treaty and sets up the Waitangi Tribunal to advise the Crown on how it should respond to claims that the principles of the treaty have been breached. So it's a statutory, it's statutory terminology. Whether it's necessary to do that, I mean, any text, as you know, it can't just be confined to the words, and you always look to principles behind a statute or a constitution or anything else. So principles can be expansive. I'm not sure that we have treated them in that way yet here, but this is a conversation we're only just starting in law, it seems to me, in New Zealand. And I have no doubt that there will be more consideration of the actual terms of the treaty and where that might take us in terms of constitutional development or statutory responses. I've done a lot of water cases, one way or another. In fact, the first claim I was involved in, Waitangi Tribunal claim I was involved in, was the Manukau Harbour case, as it's called, but it had a very important component of that was a claim in respect of the Waikato River. So I always think of my rivers. I shouldn't say that, but my heart is with the Waikato, the Mohaka, and the Whanganui. I was very lucky to be involved in some of the very first cases to go to the Waitangi Tribunal before they had the jurisdiction to go back to 1840. And they were dealing with contemporary claims. But of course, it was very hard to keep out of a contemporary claim the context and the historical context as to how the breach had arisen. And so it was important to go back. But they were very creative cases, and the chair of the tribunal then, Sir Edward Dury, he was a real visionary, and I think in those early reports, Manukau and Motunui and the Kaituna River case, which I wasn't directly involved in, although it was run about the same time as the Manukau case. And so the discussions of rangatiratanga and taonga and so on they go backwards and forwards between those two cases, and the submissions, I think, in the Manukau case may have fed into some of the report in the Kaituna case. But those, they weren't about, it was before the assets cases, I suppose, the historical wrong cases. And they were very important in educating the New Zealand public about the treaty, which had totally been lost sight of. I think probably the 50s and 60s may have been the low point in our history of forgetting about the treaty. Certainly when you go back and read some of the old cases, the treaty does get invoked. But when I studied law, we didn't even look at the text of the treaty in my law course. And I hadn't read the text of the treaty until I did the Manukau claim for Ngāne Kōminhinek. So there was a lot of catch-up to do. And I think people were amazed and to read to read of what had happened in our history. And I do think that those early reports cannot be, you cannot estimate the impact they had. I don't think any of us were trying to be successful women lawyers then. We were just trying to be lawyers. And it was quite hard as a woman getting a job, being taken seriously, and I think Lowell Goddard and I both had those experiences. So we were pushed into areas of work that we mightn't have chosen to go into, but they were very lucky accidents, and both of us have had very fulfilling lives in law. When I started off, as I said, it was quite hard getting a job, and then I had, after about 2 years in practice, I had children, and there was never any question then of or any thought that I might carry on working. Everyone in the firm assumed that I would stop. Nobody ever discussed whether I'd go back to work. So I did a little bit of part-time. I took out a barrister's ticket, and I did a little bit of part-time work in the district court, or magistrates' court as it was then, doing duty solicitor work, doing child neglect cases, doing small criminal cases. And as you say, the 70s were quite an interesting time. So there's a lot of protest activity, so I acted for a lot of protesters. And one thing really led to another, but it was all accidental. None of it was planned. When, because I'd acted for protesters, I acted in a case called the Hetawa case, which involved the engineering students lampooning the haka, and some of the Māori students who had actually been protesting against this practice for about 10 years, the Māori Students Association. Eventually there was a big fight, and they were charged with rioting, and I was one of the counsel involved in defending them, and through that we called a lot of cultural evidence, which was very interesting. I was quite worried as to whether I would be allowed to call some evidence in Māori, which indicates how much things have changed since then, and we had to square that off with the magistrate that we would be able to do that. And I met some amazing people like Eruera Sterling, who was the one who gave evidence in Māori, and his evidence was translated by Kingi Ihaka, who was an archdeacon in the Church of England. We had Graham Latimer was there, and people like Elizabeth Murchie and Ranganui Walker. So I met a lot of people involved in Māori society and the political movements, the more respectable ones than the protesters I'd been acting for. And through that and through Ngāneko, I got drawn into, that's how I really became involved in the lands case, because Ngāneko had said when the state-owned enterprises legislation was going through, I don't like this, because here we are in the Waitangi Tribunal arguing that our lands shouldn't have been taken. Here's the Crown that has the lands from which we might hope that the Waitangi Tribunal will recommend some return of lands to us. Here's the Crown getting rid of these to these corporate entities. And so from Ngāneko speaking to me about this, I rang my colleague David Baragwanath, who was at that stage doing the first of the hearings on the Muri-Whenua fishing case up at Te Hapua in the far north. And he, when he realised what was happening, asked the tribunal for an urgent recommendation, and from that urgent recommendation came Section 9 of the State-Owned Enterprises Act. And then we thought we'd done quite well with that, but Ngāneko, who is one of these people who's never entirely satisfied because she's always got a vision about where we should be going, rang me and said, well, I'm not happy about this transfer, even if there is Section 9. And I looked at that and thought, nah, she's right. There is no process to sort out the lands before they transfer. And so we went to court on that. And at the same time, I mean, this was the time of the great privatisation of the Crown's asset. The fisheries case was going ahead. Well, the Muri-Whenua people were bringing a claim about their fishing rights. It was going through the Waitangi Tribunal, and the fishing quota was effectively privatising the fisheries. So by the time we realised that this was happening, because so much was happening, we realised we had to do something about that. The Waitangi Tribunal made an urgent recommendation which the government decided that they wouldn't act on. There was a provision in the Fisheries Act, which had been there since the 1890s, saying nothing in this act affects any Māori fishing rights. Nobody knew what a Māori fishing right was. In the end, when the government said, no, we're going to go ahead with it, we applied to the court for an injunction. And indeed, I had to ring, we were in Auckland at that stage, and I had to fax, I think we did in those days, fax down to the Law Commission where I was working, and one of the law clerks, who happened to be the daughter of Sir Ivor Richardson, Megan, took the documents down, and it was after 5, and had to knock on the window and get them in through the window. I rang George Barton QC. His secretary was a bit coy about where he was. And she said, leave it to me, I will get hold of him. Well, he was actually in the barber's chair, got the call, went straight down to the court, and by 6 o'clock we had an interim injunction, and from that came the big fisheries settlement. So, you know, there was a lot happening. I was also involved in the broadcasting assets case, because that was also part of it, part of the SOE transfer of assets, and our aim there was really protection of the Māori language, and there I was working with Whatarangi Winiata and Huarangi Waikerepuru, and you know, some fantastic people, and in the end, we ended up in the Privy Council on that case, where the Privy Council said, well, the Crown still has this obligation, so let's see how they go with it. And from that eventually came some gains for Māori broadcasting, although it seems now, looking back to me, how very mean-spirited it was that we couldn't get the Crown at that stage to settle on 15 minutes of Te Reo in prime time, which is really what we were trying to do, so that it would be an affirmation of the language. So I ended up doing cases that no one else wanted to do. Nobody was doing these treaty cases. In fact, when I did the Huakina case, which is an important public law case for Ngāneko Minhinnick, because she kept going to the Planning Tribunal and protesting about discharge of effluent from cowsheds into the Waikato River. And eventually they said, well, you're going to have to pay costs because we've told you so many times you can't argue this. We don't have any powers under our Act to take into account Māori spiritual values. So we took that to the High Court. When I took it to the High Court, most of my friends-in-law were absolutely horrified. They said, You're going to the High Court, which is a big deal for junior lawyers in those days. You're going to the High Court about effluent from a cowshed and a costs order of $400. So people thought these cases were preposterous because they'd never been exposed to the treaty, to the long history of Māori claims for rangatiratanga, and they didn't know the stories of the loss of the lands. So that changed, but at the time, people thought that this was a very odd thing to be doing. And in 1987, when I asked for a show of hands at a Legal Research Foundation seminar in Auckland, about 100 or so lawyers at it, as to who had read the text of the Treaty of Waitangi, not one hand went up. So things have changed very fast. I thought that we had been in a period of amnesia for a lot longer, but of course I think the onset is maybe after the Second World War, but certainly the worst time seems to have been about the 50s and 60s. So for a woman lawyer who wasn't really getting the sort of work that she might otherwise have chosen to do, this work was wonderful. And I met so many amazing people, and I thought that I went to the Law Commission and worked on the company law reference, and I thought confidently, well, now I'll get some company law commercial briefs, but they never came. So it just goes to show, as I don't really like to talk very much about some of the experiences I had as a young woman in the profession, because I think they're just stories now. They're so long ago, and nobody encounters that direct barrier, the sort of barriers we had. Of course, you get the indirect barriers, which are more difficult to overcome. And I have been very dismayed at how long that has taken. I always did think that I'd be saying to my granddaughters, telling them some of these stories of things that had happened to me, and they would be horrified. But it is the case that we still haven't seen women making the impact in the profession that they should have made. I sense that is about to change. I think this shock we've all had about the bullying and the sexual harassment in the profession, which, if you think about it, yes, it of course it was always under the surface, and that swaggering and boys' behaviour that we put up with. I think that the shock we've had in the last few years will actually now make people confront that sort of culture, and it's the cultural change that was needed to give women the opportunity in law. The reference to the Law Commission, I'm sure, was something that Sir Geoffrey Palmer probably had put forward, and Sir Owen Woodhouse, who was the first president of the Commission, was deeply interested in that topic. It's funny, when you sent me some suggestions of things that you might talk about, and you raised the Law Commission's report on court structure, which was undertaken when I was there. I had very little recall of that report. It wasn't one that I think grabbed people's attention. And indeed, I don't think I've reread it since I left the Law Commission. So I had a look at it before coming here. And it's a very interesting piece of work, very thoughtful piece of work. But it didn't really take off in public consciousness. The Law Commission had another go at it some years after that. And that report, I think, is not a very good report. I think the one that Sir Owen, and I would guess Ken Keith and Jim Cameron all had a lot more input into it than I did, that it's a more useful document. And I'm very glad that you reminded me of it, because I enjoyed rereading it. They did not recommend the setting up of a further appeal court over the Court of Appeal. They thought that we thought, I suppose I went along with it, although I've always been a little bit unsure about that idea. They recommended that the Court of Appeal become the final court, and would be renamed the Supreme Court. But they looked at much more appellate work being done in panels of the High Court. I think probably looking at it now, and in the light of what's happened since, the Law Commission's report was probably quite complicated. And for myself now, thinking about it, I think it would have diluted the central position of the High Court in the judicial hierarchy. So while I think there are really good things in it, and we're going to have to continue to reassess what our court structure should be, I think some of the hopes they had haven't been fulfilled. I mean, I'm not sure that the Beattie Commission ideas have really been entirely successful. But I'm very pleased to go back and have a look at that report, because it's a good bit of work. Yeah. Well, not when I was a junior practitioner, because and certainly not when I was at law school. In fact, I have always wished I could go back in time and tell my colleagues, the other students, that one of us would end up being Chief Justice and one would be Attorney General, and that they would both have been two of the 6 girls in the class of 150, because they would have fallen around laughing at the thought. But I was always attracted when I became a practitioner and when I got involved in arguing cases. I always did think that judicial work would suit me well, but also I was attracted by the fact that, well, 2 things really about the judicial life appealed, apart from the intrinsic enjoyment of law, because I really do love law. First, I still wasn't getting the sort of work that I'd like to do, the full range of work. And certainly one of my colleagues, senior colleagues, said to me, you know, Sian, you're never going to get briefed in that stuff. And I thought, no, so maybe I need to go on the court to do that sort of work, because I love commercial work. I like tort, I like contract, all of those sort of things, and I really wasn't doing much of that. And then also I think the thing that does appeal to you when you've been a practitioner, particularly doing highly pressured cases in which you are very conscious of the weight of expectation of the clients and the hopes that they have, is that you get to the point where it's a relief just to come to the case as a judge and to do the best you can and to say what you think is the right thing in the case. So that, I think a lot of practitioners who accept judicial appointment get to that stage, that they want to say what they think is the right answer in a particular case.
And what would you say are the qualities of a good judge?
Well, I don't think the good judge fits any particular mould, and I think that's really important, because it's not a uniform service, and you wouldn't want people thinking alike. Judges have to be independent of each other as well as independent of everyone else. So there isn't a party line. But I do think a good judge needs to care, and needs to care about people in particular, because in the end you're exercising powers that are entrusted to you to use for the best for people, and they impact on real people. You know, it's funny, I was asked once by a class of 8-year-olds that my granddaughter got me to go and talk to, what's your favourite case? And it really stumped me, because I think the child who asked the question had been put up to it by her lawyer mother, because I can't think why an 8-year-old would think of that. And I explained to them that you don't really have favourite cases, because it's always the next case that you're looking to decide, and you're always really pleased once you've decided a case, because cases are quite hard, and you get to the point and you're convinced. That's an achievement. So I don't have any favourite cases. As to things that I floated out there that I am perhaps a little disappointed that people haven't picked up on, I think one of them is, and it's a bit boring and procedural really, is I'm very cross about the extent to which in New Zealand, we seem in the courts to entertain strikeout applications, which means it's a summary determination that this case can't possibly fly. And I think it's very dangerous to resort to that, except in absolutely clear cases where either the facts can't support what the person is seeking, or there is a statutory impediment or something like that. In common law fields, for example, in negligence cases, where the law is developing, how do you know until you've looked at the facts and you can think about the principles in the context of those facts? So I am disappointed that in a number of cases, particularly about negligence, that my colleagues and those who've come after haven't been as hostile as I was to peremptory judgments. I'd rather we took it a bit more, because the common law method is to do things incrementally, but to be conscious of the movement of law. And I don't think you can do that until you look at a problem in the in its whole context. I really don't like absolutism in legal thinking. And I mean, for example, I don't think I've ever referred to justiciability, because my view is that if a case is properly constituted and brought to the court, you decide it. You may decide that there is no breach of the law, or that it's not or that you can't say that it's unreasonable. But it's your constitutional responsibility to entertain it, and to simply use a talisman like, or a word like that, a totemic word like that, that it's not justiciable, I think is wrong. I can't say that it took up a huge amount of time or effort on my part, but I did appreciate the exposure to a constitutional element, which is of course what the Governor General is. And I mean, I also had some very nice experiences in that role, because you do get to meet a number of people outside a court setting, which is good, and people who are doing all sorts of great activities. So when you stand in for the Governor General as administrator, you're doing the formal things. You're signing the statutes. You're attending the Executive Council and signing off on I was going to say ordinances, because I'm deep in the 19th century at the moment, but the legislation that goes through the executive, and you're conscious that it's a role that has to be worked at, and it is worked at by the people in Parliament, the people in Government House. They understand the constitutional function that's being fulfilled. It's not a dress-up and social thing. There are some very nice aspects of the contact that you can have with people, but that's not what it's about. So it's also, Bagehot, as you know, said it was the Queen was part of the dignified elements of the Constitution. You are conscious that this is a dignified element of our Constitution, which you need to respect. So I enjoyed that, and it was quite interesting because over the time I was Chief Justice, which was nearly 20 years, there has definitely been a shift in how the Governor-General is, and the Administrator is treated, I think. And some of those things are maybe just getting rid of fustiness, but you have to be careful not to go too far in cutting corners on what is the correct approach. We're not always very correct in the way we do things in New Zealand. We like to be informal, but I think the Governor-General is one where you do need to observe the correct forms and not cut corners. It's a very difficult question to get across, that a constitution, like all law, moves. And so what we think of as sovereignty has to be unpacked. There are plenty of things we now do that someone like Dicey would have thought was shocking because our society has evolved. I was looking the other day at an essay that John Beaglehole wrote about the Statute of Westminster, or a series of essays actually, about the Statute of Westminster. And he made the point, and it's one of the reasons why it's really good to look at history, because you realise what movement there has been if you look back at history. He pointed out that when the Canadian provinces, I think it was probably Quebec, was agitating for representative government following the American Revolution, which of course was brought about because of the issue of representative government, Lord John Russell, who was then Prime Minister, said, well, the Queen can't have two sets of ministers. It just doesn't work. You know, there's a logic to this. And eventually he was prevailed upon to see that that was just fundamentalism, really. And things moved. The representative government was set up in all of the dominions or the colonies over the 19th century, and the sky didn't fall in. The Statute of Westminster itself, where the UK Parliament said, we won't ever legislate for you unless you ask us to. Well, on Dicey's theory of parliamentary sovereignty, that's impossible. And you sort of cover it up by saying, oh, well, in theory they could, therefore they've retained sovereignty. But actually, the reality is the world has moved on. So, yes, Parliament under our system can make or unmake any law. That's what parliamentary sovereignty is, and there's no authority in that's binding on us that would go against that. But as was recognised when the New Zealand Supreme Court was set up, parliamentary sovereignty is one of the principles of the Constitution. The other is the rule of law. And while I don't I think you have to be careful about the rule of law, because it can be a bit used as a talisman too. What it means is that Parliament, just as, say, the judges have to do not what they would necessarily like to do, but what they ought to do, so too Parliament operates within a constitutional setting. And whether or not it can be legally constrained, it does have constraints. It's got to observe Magna Carta. It's got to, or the parts that still apply. All of those things are the context in which Parliament operates. Now, whether we will evolve. I mean, you can see the Constitution evolving in the United Kingdom. The prerogative was thought to be something that the courts couldn't control. Now, of course, they can. You are, I think, seeing the courts understanding in a number of jurisdictions that they operate in a democratic constitution, and that statutes which impact upon the democratic franchise will be very strictly looked at. And, we've had a few cases like that. We've got the Electoral Act that requires a super parliamentary majority. In strict theory, if you're looking at parliamentary sovereignty, if that happened, well, too bad. Well, we had the Solicitor General arguing in the Supreme Court that if a super majority had been required by the Electoral Act, the Solicitor General would not argue, if that had been breached, that the law was valid. Well, that is revolutionary if you take a very absolutist view of parliamentary sovereignty. Well, in New Zealand, I think the main threat to judicial independence is if it's not properly understood and it's not supported. Judicial independence exists to ensure that judges are impartial in judging. But it's maddening, really, to have people criticising judges when they do their job. You can criticise the judgment, of course. You can disagree with the judgment. In fact, I wish more people in our community would bother to read judgments and make criticism of them. But to say, as we keep hearing, and from people who should know a lot better, that judges are unelected and unaccountable is damaging, because it undermines confidence in the judiciary. Those are just epithets. Then they're very rarely unpacked or substantiated. And the truth is, you wouldn't want judges to be elected, because in jurisdictions where they are, there's a real question as to impact on impartiality. So judges are unelected for very good reason. And as for unaccountable, I really struggle to think of many occupations where people are more accountable, because judges can't exercise judicial authority at all without giving reasons. And then they're subject to appeal. Now, a final court of appeal, you might say, doesn't have that check. But if the reasons don't stack up, or if Parliament doesn't like it, Parliament can change it. So I think that is lazy reasoning, these attacks on judges. Say why you don't like their judgment. That's fine. But I do think that's a threat to judicial independence. I think it is very concerning that that we are seeing a lot of statutes in which the jurisdiction of the courts to supervise is either removed or there are attempts to remove it, or it's cut down by procedural limitations. And you can see in the United Kingdom there's quite an assault on judicial review at the moment, and that bothers me, because I do think that judicial review is pivotal in our constitutional balances, and somehow we have to get over to the community why it's a protection for our whole system, our whole constitutional system. In a law state, you have to allow supervision for legality. You can't have people saying, look, it would be a good idea to do this. If they don't have lawful authority to do it, then they can't. I'm cautious about a written constitution. As you know, a written constitution is never complete. You always have to imply things into it. There's a very great difficulty in allowing organic development of a written constitution. The dead hand of the framers can weigh it down. So my preference personally is against a written constitution. But that depends on whether we are prepared to work harder at our unwritten constitution. And it's not enough if judges and lawyers are in on the joke, if they understand the workings of the constitution. Everybody has to be interested in how the constitution works, and everyone has to respect and support the different elements of the constitution. So if we get to the stage where, and I think we could do a lot more, frankly, to bring people into the constitution, I think we should pay more attention to whether we have as much lay participation and involvement in law as we could have. It's interesting to read some of the recent histories that have been written about litigation, for example, in Elizabethan times and afterwards, because obviously access to justice was much cheaper, and people participated more. They knew what the laws were. In fact, there weren't that many statutes, but things like the great charters were read out at the beginning of the assizes in England. So people were interested, and that carries down in early New Zealand. The newspapers are full of court cases, arguments about legal matters. People had to be bush lawyers, a lot of them, because there weren't many lawyers around, and people carried Blackstone around with them. And you know, Kenton's Story, we know those digests were very popular in early New Zealand times too. So somehow we've lost that sense. Laws become so much more specialised, and the preserve of lawyers, and lawyers have got increasingly expensive. So somehow we have to break that down. If we can't get public buy-in to the Constitution, then maybe we do have to look at capturing some of the elements of the Constitution, as we have done, for example, with the New Zealand Bill of Rights Act. It provides a very useful checklist, but then again, I'm not sure to what extent anyone other than lawyers reads it.
Thanks very much. That was excellent. Dame Sian, thanks very much for that.
Thank you.